I wonder if Florida is trying to beat Texas to the role of biggest a-hole among the 50 states. Florida just affirmed in the Fifth Circuit Court of Appeal a ruling which would require somebody convicted of a sex offense to put a stamp in onto their driver's license, indicating that they're quote a sex offender. Again, it's important to understand how easy it is to actually get on the sex offender registry. People think, oh no, you're just saying that. No, almost a million people are on this stupid registry across the country because it brings in lots of money. It makes politicians look good, and it does absolutely no good at all except to stoke fear and apprehension and to create even more misunderstanding. So here we have a situation where it just exemplifies all those things in one ruling. Judge Pratt, in his 31-page ruling, said that this was not, as it had been previously ruled in the lower court, compelled speech. In other words, you're forced to proclaim to everybody around you that you are a sex offender, which some places, by the way, have tried to do when you enter anything. Here in Virginia, for example, they passed a law a few years ago that if you end up in an emergency shelter, the first thing you have to do is go announce to the center director, who of course doesn't have enough to do in a crisis of chaos, that you are on the sex offender registry. So Judge Pratt said, well, it's really not compelled speech at all. There's no difference between that or the state putting your height and your weight and your eye color onto the license. But Judge Pratt, it is different. It's very, very different. For one thing, your height and your weight and your eye color doesn't cause people to want to hurt you. I don't know of too many vigilante groups that are going after people who are under 5'8" or over 6 feet two. Then, of course, there is the eye color vigilante groups, which also don't exist. This is an awful, horrible thing that is on public registries. And of course, I'm not a fan of any registries, but the public registries at least make it easier for you to be looked up, harassed, threatened, and injured and even killed. And we've seen these incidences over and over again. And the state views them basically as, when I say the state, I mean any government in general, basically thinks of them as the cost of doing business. Certainly, nobody rises to the defense of those who are on sex offender registries, even though we have argued many, many times and demonstrated, shown scholarly articles, they do nothing, zero, to help anybody. All they do is bring in revenue to the states that the states use for their general budgets, and it saves no one. The compliance officer that I have and that others have here, I won't name him, but he said, I don't know that the registry is useful at all. He says, I am worried only about 10% of the people on my list. He has a 250 person client list, and about 10% of those, he says, I'm truly worried about. The rest, I'm not. And I would say probably you could pare that down just a bit, maybe down to 5%. So once again, Florida distinguishes itself as the jackass out there. Uh, Remember, they have a law now which says that you could be killed for the more strident offenses. You can be harassed. They are in certain counties trying to restrict where you can settle, where you can stay, where you can live, as opposed to a place in Wisconsin recently where they recognized that they changed the law and thereby made it demonstrably more difficult for people who had been convicted of sex offenses where they would live. So they granted a waiver program as well, grandfathering people in. That's at least a more intelligent and sensible approach to it. But Florida will not be happy until they create even more problems for people convicted of sex offenses, not to mention the fact that you can't even visit the state for more than 24 hours without having to register with the local police, and then you better check what state you're returning to, as in the case of the Indiana man who moved from Illinois to Indiana, both of which has a 10-year registration requirement under which his offense is classified. And when he went to Florida, he spent a wonderful week or two there. But he did not know that when he returned to Indiana, their requirement there said that if you go to a state which requires you to register, doesn't say for how long, and you return to Indiana, you are under the more restrictive rule. So he went, because of his 2 week vacation to Florida, he became a lifetime sex offender under the registration requirement of Florida. Same thing in Arizona. They also have a lifetime registration. This is why prosecutors very often will say, we'll waive jail time, but you got to be on the registry because, of course, the more people they pack in, the more money the state gets. So, it's quite the little money making operation that does absolutely no good for anyone. And Judge Pratt deludes himself by parsing a little bit of sliver of the law by saying that it's no more onerous, it's no more difficult than you displaying your eye color, etc. No, sir, it is. It creates a situation where the public is at risk because the public is inflamed, impassioned to go after this person. Every time you have to show your license for something, you are at risk of being profiled. And that should not be allowed in the United States at all.